Welcome to this webinar about people being resettled from Afghanistan and Ukraine. The focus of this talk is going to be on Afghan migration issues, but we're also going to try and touch on recent issues involving Ukraine and also housing and benefit points. There are 4 talks today. The first of them is by Donnchadh, who's going to talk about a case law update on eligibility for relocation under ARAP. Then Catherine will take over and talk about ARAP and leave outside the rules, so published and unpublished policies, practice and disclosure. We're then delighted to be joined by Erin Alcock from Leigh, who's going to talk about suitability decisions made by the Home Office in respect of entry clearance for Afghans who've been found eligible for relocation. And then I'm going to bring up the rear and talk about national security and discrimination issues and a couple of housing and benefit points relating to all of this. Our bios and seminar notes are in a pack which I hope reached you. It was sent by email shortly before the seminar started. And so please do refer to that pack for notes for the seminars. I think some of the more technically adept speakers will be putting notes up on the screen, but I'm afraid I'm not quite capable of that. If you have any questions as we go along, please do put them in the Q&A at the bottom, and we'll try to answer them as we go along, or at least at the end of each talk. Otherwise, I hope everything's pretty much familiar to you, and so I will, without more ado, hand straight over to Donnchadh.
Thanks, Adam. We're just going to get my wee slides up. So I'm going to provide a kind of rough overview of some of the key cases that have concerned individuals who've made applications under ARAP. Could you do the next slide, please, Meredith? And so I'm sure many of you are familiar with ARAP, but what I thought was helpful to frame it in the context of was considering what is the kind of purpose of the policy and when it was introduced to assist and relocate people from Afghanistan following the Taliban takeover of Kabul. And so what Mr. Leigh said, and he was quoting a witness statement from a civil service member from the Ministry of Defence, was that it was a way of showing commitment and paying a debt of gratitude. So for the 20+ years in which the UK were in Afghanistan, they obviously worked with a lot of people on the ground. As a way of, it was framed as a way of showing a debt of gratitude to help those who are maybe at risk because of that work relocating to the UK. Next slide, please. And so the focus of this will be on the 2 prongs. First, eligibility as being considered in the courts, and secondly, consistency. And so I'll come and explain why those are the 2 points at which I've separated the talk shortly. So just to give you a brief background on ARAP, next slide, please. I won't go on this for very long. It was introduced in April 2021, so a good 4 months before Kabul fell to the Taliban. It's last been updated in January 2023, and the most important thing for clients will be, or for applicants will be, what is the policy in force at the time? And it's gone through various different iterations. The key category that we're going to look at today, and the focus of most of the case law, is category 4 and the so-called special cases category. And in this case, it's divided into 3 criterion that must be satisfied, or alternatively a 4th criterion. So the 3rd and 4th appear to be interchangeable. And so in this context, what category 4 looks for is whether you worked in Afghanistan alongside a UK government department in partnership or closely supporting and assisting that department. So the first 3 categories of ARAP relate to direct employment or more closely related employment. And this is more for those who maybe facilitated work for the British government, did different roles, and it's looking at that. And so it adds further criteria by making a substantive and positive contribution to the achievement, and also that there must be an elevated risk of targeted tax, death, or serious injury because of that work. Alternatively, the individual may hold information which would give rise to or aggravate a specific threat to the UK government. Next slide, please. So what's that mean in practice? Well, during the CX1 litigation in which all of us acted, it came to light that there was a standard operating procedure that was used as guidance to help assist decision makers make decisions about eligibility under the criteria which are fixed both in the immigration rules and in the policy online. Now, you can look at the full points around that at paragraphs 38 to 45 of the judgment in CX1. But there's some interesting points I wanted to briefly highlight before moving on to the actual case law. The first important point is that the first decision that seems to be made is that subject to agreement of senior officials from Home Office, Ministry of Defence and Foreign Common and Development Office, Commonwealth and Development Office. This is the first stage an individual goes through, which might seem slightly curious if different departments can also sponsor people. And then it goes through various different other officials and ARAP officials decide it. Next slide, please. And then, as I said, the ARAP policy officials will look at it, and even if someone doesn't know someone individually in a specific department, they're seeking to sponsor them, and they can just set out the reasons why it is. So in some ways it mirrors it, in some ways it's slightly different, as we argued in the case. However, Leigh ultimately held that there was no material difference between the two policies. But it is a useful guide in thinking about how applications are framed, and I think Catherine's going to touch on that later. Next slide, please. And so I won't go into detail or read every single slide, but what we're looking at in the case of CX1 was 8 journalists who said that they were eligible under category 4 because their work for the BBC, and they were former BBC journalists, was that their work worked alongside and closely supported the UK government's military and national security objectives. So these were individuals who reported on counterterrorism, counter-narcotics, exposed some of the corruption within the Taliban. And they said that this work had put them at a greater risk, and they considered themselves to satisfy the criteria under category 4. The Secretary of State disagreed and rejected each of their applications in more or less identical and unparticularized terms, simply stating that they did not meet the first criteria, that they worked alongside or closely supported the UK government. At this point in the case, when it was issued, there were 3 grounds, and the first ground, which I'm only going to touch on, was there was a failure to give any reasons or any adequate reasons for the decisions, and that was therefore unlawful. Next slide, please. However, when witness statement came through, it turned out that it appeared that the government had framed this decision on the basis that the BBC was not part of the UK government. And so therefore, the claimants argued that this was an error of law and they'd materially misunderstood the policy. Next slide, please. So just because the BBC was independent didn't mean that it was not they could not satisfy the working alongside or closely supporting criteria. And also they raised the point about identifying a sponsoring unit. Next slide, please. And then during the proceedings, in breaches of duty of candour, further information came to light from the caseworker themselves, who had made the decisions in relation to the 8 journalists. So first of all, in relation to CX1, it was explicitly said that CX1 was not employed by the UK government and therefore was ineligible. In relation to the rest of the claimants, it was saying that the assertion that working for the BBC qualifies for the applicant as being employed by the UK government is refuted, and therefore they were also ineligible. This, Mr. Justice Leigh held at the outset, was an erroneous interpretation of how the eligibility criteria applied, and that it was at least likely that although it was much more unequivocal in CX1, that carried through to CX2 and CX all the way to CX8. Next slide, please. And this is just a brief overview of how Leigh considered the policy around being an objective question for the court. What would a reasonable, literate person's understanding of that policy be? The Secretary of State for Defence raised the point that, what they did during Operation Pinning, so evacuating a lot of Afghan journalists who didn't qualify under ARAP, was irrelevant, because what the question for the court was whether at the time the relevant wording of category 4 was such that they could satisfy it and be considered eligible. Next slide, please. And so interpreting policy, he separated it into 2 points, which are relatively obvious from the immigration rules and from the policy about working in partnership with or closely and supporting and assisting it. And he gave almost a spectrum of how physically working alongside a UK military unit might not be sufficient, but being more closely aligned, being embedded, or being working closely with the the UK military, that might satisfy it. and it's just to emphasize here that it's about likelihood. So it's not saying that physically alongside might never satisfy it. It was about the more likely instances would be where they were much more closely aligned. And next slide, please. And Leigh, Mr. Justice Leigh gave examples about how an individual who's a journalist could satisfy the substantive and positive contribution towards the achievement of the UK government's military objectives. So matters such as the provision of intelligence and informing the Afghan population of the corruption of the Taliban. The first one was a point that was raised by the Secretary of State for Defence in reasons why other journalists were brought over during Operation Pitting, and the second one I think was of his own invention. And what was the most important thing to emphasize was that the Secretary of State for Defence should consider this case-specific facts of an applicant. And when in this case they didn't, and immediately held that they were not eligible because the BBC was not part of the UK, the Secretary of State for Defence had erred. Next slide, please. Just briefly to touch on the reasons challenge, you can see this at the paragraph 72 and onwards in the judgment, where or previously, sorry, 60 odd and onwards, and where it was looked at whether the operational reasons were such that the ARAP reasons couldn't be given, that they were only, that it met the common law duty of fairness to give brief and translated reasons into Pashto. And so Leigh held this was sufficient given the hundreds of thousands of applications under ARAP that were received, and that they were working at speed and trying to make sure that decisions involving the right to life were made quickly. What was particular in this case was that the claimants were able to mount a challenge, and that they were able to challenge that decision notwithstanding the sparse reasons. And I'm going to touch again on this at the end. But what's to emphasize again is the case-specific facts, and whether the court should be slow to find that operational requirements permit the decision maker to do so and bypass detailed reasons. What the question is about whether someone can bring a legal challenge. And again, I'll touch on that later. Next slide, please. And so other cases that have looked at our eligibility under ARAP have all been refused permission on this ground to challenge the eligibility decisions on rationality. So SNAZ and JZ all initially launched their claims alongside Leave Outside the Rules challenges on the basis that that the decision to refuse them under Category 4 was irrational. Curiously, it was Mr. Justice Leigh who refused permission in that case, but it will become a bit more obvious about why that may have been in the case of these three judges. Next slide, please. So what the three judges did was they reformulated their challenge and said that there was a material inconsistency between the decisions in their cases and the decisions made concerning other judges whose circumstances were not materially different from theirs. So in essence, looking at individuals who were granted ARAP leave during Operation Pitting, which included a number of judges, in particular in all the cases, they referred to 13 judges, that these situations were not materially different from theirs, and therefore there had been it was irrational to refuse them leave on that basis. Next slide, please. Now, it's important to also consider that here the criteria that were being applied under ARAP was different at that time. So this is September 2021. The change happened that it used to be in meaningful enabling roles for the UK government, and it became alongside, which is now still in the policy. But it had what appears to be a much higher bar about extraordinary and unconventional context, and that the individual was able to build a credible case for consideration under the scheme. The latter part, credible case, does make its way into the standard operating procedure, and so the individual still appears to have that criteria, even if it's not in the policy as it stands published and in immigration rules. Next slide, please. And so just a brief background on all these judges. They were judges who had all made decisions in counterterrorism cases. They had all sent Taliban fighters to jail and other terrorist organizations to jail, and following the release of a lot of those individuals, they were in fear for their life. They had faced real and credible threats that was not disputed by the UK government, including S, who was a female judge whose husband was who became paralyzed as a result of Taliban attacks and torture. In essence, the reasons given were quite lengthy in these cases, and I'll deal with that slightly in a second, but they have not provided any evidence of any link to a UK sponsoring department. So there was no evidence that supported their claim that they worked alongside a UK government department. They said that just because they were judges didn't mean that they had made a material contribution to the UK government mission in Afghanistan. The government did accept this benefited the UK more broadly, but it didn't make a material contribution because the UK government wasn't involved in any of their courts, didn't train them, and they didn't meet them at any point. And therefore, as a consequence, they weren't subject to any risk because of working closely with the UK government, because they hadn't, in the government's view, worked with the UK government. Next slide, please. And so during quite detailed pre-action correspondence, the reasons were provided for their refusals. At that time, it appeared to be that panels were being set up, so quite distinct from the claimants in the CX1, where there was brief reasons made by a caseworker. The panels were convened in various departments looking at what the reasons were, examining their reasons and giving quite lengthy reasons about why, and also giving lengthy reasons for subsequent reviews, which maintained the decisions. It was argued by the claimants that the government was interpreting the ARAP criteria too narrowly. However, again, here's the point that returns about the debt of gratitude there is based on recognition of service and the likely and future risk because of the close work with the UK government. Next slide, please. And so what the judges did, as I said earlier, is they reformulated their challenge to say that there's these 13 judges you evacuated during Operation Pitting. We were in similar circumstances. We worked for the Afghanistan government Afghan state as judges. We worked in courts. We tried terrorism cases and criminal cases involving Taliban fighters, and so did these 13 judges who appear to have worked in the appeal court in Kabul, anti-terrorism court in Kabul, sorry. In particular, one individual, Judge W, gave a witness statement in support of the claimants in both of their claims. And he said he didn't work directly or indirectly for the UK government or military. He had been invited to the British military or British embassy, but had met British officials. But it doesn't appear that he was aware of the reasons why he was given ARAP. And in particular, at that time, the policy was still for and not alongside. So it was quite tenuous. I would say the argument was that he did work for the UK government. Next slide, please. In SNAZ, Leigh said again that it's a case-specific evaluation of the individual facts. What the defendants had said was about the closeness and the role of them presiding over the UK, the anti-terrorism court, which benefited the UK government and had a working relationship with UK officials in Kabul, and had been trained by them and been supported by them in various ways, logistically and operationally. In particular, what appears to be a factor is their higher profile role and that they were at an elevated risk from the Taliban. Next slide, please. And so I'm not going to go through each one of these things, but in essence, it boiled down to, for AZ, that he couldn't show the link. He hadn't been involved in any close proximity with the UK. He didn't receive any training, as did the 13 other judges. And indeed, a sponsoring department did consider his case, but didn't know him, and so wasn't able to identify him as someone who had made a material contribution in that way. Next slide, please. Again, the defendant said in relation to S, essentially the same reason. There's no reason to say why, but for her work, that the UK's mission would have been adversely affected. And it wasn't denied that any of these individuals were at risk, but it was just that risk wasn't linked to the UK government and working with the UK government. Next slide, please. And so therefore, Mrs. Justice Leigh held that there was no inconsistency amounting to irrationality. And so it's distinct from CX1 in the sense that showing an error of law and misinterpretation of the policy is slightly less higher hurdle to overcome, but you have to show irrationality in this context. And yet they weren't able to do so given the distinguishing factors. Next slide, please. In a slightly different judgment in JZ, so originally all the claimants were joined together but separated off owing to Part 18 requests, Mrs. Justice Hill took a slightly different approach and kind of emphasized that where it's a discretionary decision making, it will be much harder to show that it's irrational, particularly when you can reach different decisions on similar facts and still be considered to act lawfully. And that was based on a Supreme Court case. What Mr. Justice Hill looked at was whether the judge in question had sufficient link with the UK government in accordance with the wording of the ARAP policy. As in SNZ, it was about whether the evidence was that the 13 judges was broadly consistent, given that they had worked with the UK government via the Anti-Terrorism Court in Kabul, and there's 2 other organisations. Next slide, please. What was interesting about JZ's case is that a key difference between Judge W and the other judges in JZ was about the time at which they were working, and this will feature in slightly later on when we look about why people are being refused. And so 2011 versus 2015, and 2015 all the way through to when he was evacuated was the case for Judge W. And again, while it was not time limited, it was about whether the UK government could say that he worked alongside them. Next slide, please. This is just some brief criterion that Mr. Justice Hill set out about why the judges might be considered to have worked alongside as opposed to the other individuals. And you'll see these are just really emphasizing the proximity at which these judges should have been or would have been working with the UK government versus 13 judges who were evacuated. Next slide, please. Interestingly, the parties all accepted there was a residual discretion under ARAP for the defendants to exercise, which constituted exceptional reasons for treating what is so-called the outlier judge, potentially Judge W, who the UK government admitted they weren't aware of why he was accepted, as a basis for allowing him to relocate under ARAP. And essentially, in brief reasons, it was that there was just because of a small number of cases doesn't mean that it showed the overall scheme was incoherent or inconsistent. Therefore, the distinguishing factors meant that there was no inconsistency such as irrationality that meant that JZ should have succeeded under ARAP. Next slide, please. And so drawing some brief threads together to close, considering what I've just maybe gone through in quite a whistle thought tour, it really seems that what you need to be able to show is that you know someone personally in the civil service who you worked with or someone who worked on the ground with you, which seems like an impossibly high hurdle to meet, considering when you think about JZ having worked in 2011, potentially if he even had have met UK government staff members, would he have been able to satisfy that criteria if that staff member no longer worked there? When considering the debt of gratitude for 20 years service, for 20 years being in Afghanistan, it's likely that a lot of people will fall outside this given the length of time, and ARAP might not work in the way that the UK government has necessarily intended, or perhaps is working exactly as they intended. And similarly, it was interesting to note about the different approach between the panels and the caseworker and CX1 and the judges, and also just emphasizing the public profile. Next slide, please. And so just to finish off on 2 possible future challenges, it's likely that in other cases you would be able to mount a reasoned challenge based on the basis of what is given in an ARAP challenge, given that the only reason the claimants in CX1, etc., were able to challenge the real reason why they were refused was because the reasons were disclosed during the course of proceedings. And you could argue that operational requirements are such that actually you should be disclosing more reasons. It's not that every reason needs to be as detailed as in the judges' cases, but something more and something more material would have allowed the claimants to formulate their challenge properly at the start in the BBC journalist cases. Next slide, please. Again, it's a question of fact and degree. Also, just the last thing to flag is the residual discretion under JZ. How far did this extend? What do we know about it now? Does it still exist, or was it limited to Operation Pitting? It might be something worth exploring in some future challenges. I think that's me. Next slide, please. Thank you.
Great. Okay. Thanks very much, Donna. And sticking pretty much perfectly to the 20 minutes, I'll hand over to Catherine.
Afternoon, everybody. Following on from Donna's brilliant presentation, I'm going to start with the words of the Foreign Affairs Select Committee in its report in May 2022 called Missing in Action, UK Leadership and the Withdrawal from Afghanistan, that the manner of withdrawal from Afghanistan was a disaster and a betrayal. The total absence of a plan by the FCDO and the Home Office for evacuation and the lack of clarity in the schemes led to confusion and false hope among Afghan partners who were desperate for rescue. They were utterly let down by deep failures of leadership in government. The committee continued that the Foreign Office had not been open about these failings and gave answers that, in our judgment, are at best intentionally evasive and often deliberately misleading. The committee recommended that the FCDO should review its internal processes for officials to register concerns and to report back. The government reported back that a lessons learned review had been conducted and apologised for, quote, inadvertently providing misleading evidence on the handling of evacuations. It's not clear what policies were reviewed or what lessons were in fact learned, because in practice, as we all know, the ongoing lack of clarity and transparencies in the policies that govern these schemes, which were set up on their face to evacuate Afghan partners, continue to fail to deliver the bare minimum owed by that debt of gratitude. This session looks at those policies and practices, including the published policies and the unpublished ones, which have been revealed via disclosure requests. The aim is to provide a practical overview to help navigate these schemes and to stress the utility of disclosure in all of these cases. It comes with a caveat that this is based on an understanding of the cases that I have worked on so far, and it's anticipated that others in this virtual space or generally may well have different experiences, and that's because of the nature of these cases where so much material is unseen. Please do share any experiences at the end. On ARAP, on the Afghan Relocation and Assistance Policy, I'm going to make 5 short points. First, on eligibility processes, which Donna has already touched on. Second, the role of the sponsoring unit. Third, reasons. Fourth, reviews and prioritization. And fifth, disclosure. So first, on ARAP decision-making processes. An ARAP application is made, as we know, on the online form and sent to the Defence Afghan Relocations and Resettlement Team, that's DAR. That's within the MOD, and it's processed, as we know, in 3 stages. And the reason I'm pointing that out is that the published policies refer to 2 stages. That misses out, it skips over the role of the sponsoring unit. So stage one is the sponsoring unit referral takes place. That's the government entity alongside which the applicant worked prior to the Taliban takeover, be that the FCDO, formerly DFID, the Ministry of Defence, National Crime Agency, others. The sponsoring unit will decide eligibility and accept or decline sponsorship in practice in many cases. 2 is the ARAP decision. The sponsoring unit decision on eligibility is sent to ARAP, which apparently agrees with it either way. If not eligible, ARAP refuses eligibility. If eligible, then a positive sponsorship decision is made and then a relocation offer generated. It's then sent to the Home Office. That's stage 3. The Home Office stage 3 decision is made under the immigration rules, which are in Appendix ARAP, paragraphs 3.1 to 3.7, subject to any general grounds for refusal in Part 9 of the immigration rules. The role of the sponsoring unit is important. The sponsoring unit may be the operative decision maker and the defendant, and it's important to know that, to identify what the operative decision is to challenge and to identify the appropriate defendant in a judicial review. The face of an ARAP refusal decision by the MOD or the DAR team, let's say under category 4, will refer to the assessment of eligibility having involved making checks with the relevant HMGG department or unit, but you may not know which department or unit that is. The published policy and practice also refers to referrals by the MOD to a sponsoring unit if appropriate, or alternatively, if the FCDO is the relevant government department. It's not really clear what that means. But in practice, there are three approaches that might be seen. One, no MOD referral if the case is deemed not eligible under internal arrangements or standard operating procedures, SOPs, or as in the cases of CX1 to 8, as we saw, the applicant did not self-identify a unit, see paragraph 23 of the judgment. Second avenue is MOD referral to one or more departments requesting sponsorship, which seems to be that if declined, that's the end of the matter and that a refusal decision will be generated. An avenue, option 3, seems to be the MOD referral to the sponsoring unit, for example, the FCDO, which makes the eligibility decision, and that may be determinative of the case, because then the case is referred back to the MOD, which accepts it. The potential importance of the sponsoring unit's role in decision-making is clear from the judgment in the Court of Appeal in JZ. As we've heard, JZ was an Afghan judge assigned to hear terrorism cases in the Justice Centre at Bagram Air Force and a public security centre at Kabul prison. Sponsoring was referred to as a building of a credible case for consideration. You see that in the policies, but it also means decision-making. So in JZ, or JZ, I don't know if we call him JZ or JZ now, but seem to have turned him into JZ. There were 3 secretaries of state formally identified as defendants, Secretary of State of the Home Department, Commonwealth and Development Affairs, and Defence. However, the court in substance was only concerned with the decision of the FCDO taken by the head of the counter-terrorism Afghan task force, the decision maker. In practice, what we see is there are unpublished SOPs relating to different organisations and units, but they also point to the FCDO's role, even if that is not apparent from the face of a received decision. So moving to the reasons that may not be the reasons conveyed on the decision versus the real reasons for refusal. The reasons conveyed on the face of a DAR decision will just recite the ARAP category and criteria and state that the applicant is ineligible in a refusal decision. And the real reasons will be found in a caseworking note by an FCDO decision maker or a DAR team caseworker. In JZ's case, the decision maker's written reasons showed that there was a bundle of evidence submitted by the applicant, and the conclusions were reached on the Afghan counterterrorism task force decision maker's own knowledge developed through heading the counterterrorism team in Kabul, and further information. In CX1 to CX8's case, the reason given by the DAR caseworker in caseworking notes that were disclosed in the course of proceedings were not conveyed on the face of the template decision. And Mr. Justice Leigh held that the caseworker's reasons, i.e. the real reasons for refusal based on the BBC not being part of the HMG, were legally erroneous. See paragraph 92, as Donna has said. So importantly, the template decision may not convey the real reasons, and they may not even provide the precise ARAP category 4, just focusing on that, conditions expressly accepted or rejected, and definitely not the reasons why. So remember, the category 4 conditions are working alongside, in broad summary, 2, contribution, 3, risk, 4, intelligence. And the applicant won't know, in some cases, which of those conditions necessarily have been the operative the operative conditions for forming the basis of the refusal in the case. So requesting the documents relating to case working notes, the FCDO decision-making, ARAP, DAR and MOD decision-making, the FCDO minute, the MOD DAR minute of decision, communications between the departments and then a sponsoring unit will be very, very useful starting points. Fourth, other procedural aspects, whizzing through, there are requests for information. Requests for information may be made of an applicant by the DAR team at any time. There is a review process, as we know, against ineligibility decisions. One right to seek review absent exceptional circumstances, and that should be submitted within 90 days. Further reviews may be, in some cases, as Donnchadh said, the ARAP review panel may be convened to reconsider the application, see JZ paragraph 9. Timescales and prioritisation requests. The evacuation schemes are characterised by chronic delays, and the published policies on expected timescales for ARAP decisions indicate they should be made in 2 to 4 weeks. In CX1 to CX8's first judicial review, challenging the delay in making ARAP decisions, the government apologised for failing to progress or prioritise some of the cases and for having lost one entirely, with an undertaking to conduct a lessons learned exercise. The claimants waited 10 to 12 months for their ARAP decisions, which were those then refused and challenged, forming the basis for Leigh's judgment. There are no published timescales of which I'm aware relating to ARAP reviews. It's an open-ended timescale. Arguably, those timescales should be consistent with the published policies on decision-making and the overall purpose of the scheme to help those where their lives are at grave risk. In practice, applicants can make prioritisation requests, both for the decision-making process under ARAP and reviews, and it's important to establish whether or not any decision has been made by the DAR director on prioritisation, and to obtain that from the government legal department or otherwise. Timescale issues with the reviews will be obviously highly relevant in judicial reviews. The fifth issue is disclosure, disclosure, disclosure. I feel like saying it 3 times might sort of magic disclosure out of the air, or maybe I should just call this open sesame. But either way, this is absolutely critical. And lawyers and everybody should use every single tool in the box to get disclosure in these cases, including subject access requests to the MOD, to the FCDO, to the Home Office, disclosure requests per action, Part 18, and also freedom of information requests if necessary. And that's all in addition to disclosure as a result of the defendant's so-called duty of candour, which was breached and an apology issued in CX1, see paragraph 27. We see the utility of disclosure in JZ's case, that all, as Donnchadh said, JZ's appeal in the Court of Appeal essentially arose out of a disclosure exercise before Mrs. Justice Hill. And in CX1, the disclosure of the case working notes and the SOP really went to the heart of the case and the crux of why the decisions were quashed. See paragraphs 38 to 45 and 133. There are clearly procedural fairness issues arising here relevant to further challenges. If there are doubts about eligibility, they should be put to an applicant to provide an opportunity to make representations about them. That's standard common law fairness, see Balajageri. Further, if there are unpublished policies which inhibit the applicant's ability to address the correct eligibility criteria and to challenge an adverse decision, that may be unlawful on the lumber principle, may be unlawful. And that's relevant in terms of the making of a first eligibility decision, to any request for information and to a review request, because in some of these cases there are rolling requests for information. But if the applicant fundamentally doesn't know the criteria on which he or she has been refused, and the criteria he or she has to meet, it's unfair. So knowing the case against is of vital importance. Just quickly, if I've got time, looking at Adam through the screen. Thank you. Just going to touch on leave outside the rules. Before drawing this to an end, leave outside the rules, or LOTA, is relevant in this context because, as we know, during the evacuation in August 2021, ministers developed a separate policy to enable certain groups of people, special cases, at-risk cases, who were thought not to qualify under ARAP to relocate to the UK. Became known as Pitting, Operation Pitting, Leave Outside the Rules, or Pitting LOTA. And the judgment in S sets out the entire background to that. The government has accepted in the second missing in action report that I started with before the select committee that the nature and scope of the effort to help Afghans who did not qualify for ARAP was poorly communicated publicly. This includes the LOTA policy that was developed in March 2022 that covered Afghan cases. Now, the LOTA, leave outside the rules, is a power of the Secretary of State for the Home Department to grant leave to enter or remain outside the rules as a residual statutory discretion under Section 3 of the Immigration Act 1971. Ordinarily, it's exercised in exceptional cases. This is just standard immigration law. The ARAP decision letters, refusals on stage 1 eligibility by the MOD do include generally a line saying, referring to the power of the Secretary of State to grant leave outside the rules, but they don't suggest that that discretion has been exercised. Now, as I've said, post-Pitting in March 2022, the Home Office policy, leave outside the immigration rules, mandated the use of a particular application form for those applying for LOTA from overseas. And those were the visa application forms under visitor, worker, family, or student. See the judgment in S, paragraphs 11, 14, 26. The policy says an applicant must use the form for the route which most closely matches their circumstances and set out compassionate factors as to why they qualify. CX1 to CX8 challenged this LOTA policy on the grounds that it unreasonably or unfairly required ARAP applicants to use online VAFs, which did not remotely match their circumstances as matters stood. They could not complete. The evidence before the court was that applicants could not complete the online VAFs by adding non-applicable to various questions. For example, if they weren't a visitor or they weren't a student, or they couldn't put in information about their finances, they couldn't put information about a family member that didn't exist. And it was argued that they had to sign a declaration on the form saying that the form was true when it wasn't, and that put them at risk of being refused, being banned from the UK, or being prosecuted. Mr. Justice Leigh, like Lord Justice Underhill in S, thought that this policy was suboptimal, but did not find the approach to be unreasonable to the point of being unlawful. And that's because there's a free text box in the form that you can say that the entire premise of the form is completely untrue. And that you really want a humanitarian visa, but Mr. Justice Lane thought that'd be okay. As Donnchadh indicated, there may well be further challenges. Just to highlight on that there have been some cases where people have made, let's say, a visitor visa application. They've applied for LOTA on a visitor visa application form, and said, this is not a visitor visa, this is a humanitarian visa. And the Home Office has gone on to refuse that application on the basis that the person is not a genuine visitor, because they do not want to leave, they want to actually stay, and then gone on to refuse LOTA on exceptional circumstances. Finally, there's a biometric, there is clearly a biometric requirement for any application for entry clearance, whether it's under ARAP, once the eligibility decision is made by the Home Office, or if it's LOTA. And in a country without a functioning government, the biometrics requirement will likely be insuperable, because there is no such place as a visa application centre to provide biometrics, i.e. photograph and fingerprints, and it's too risky and unsafe to travel to a third country to do so. Been a whole range of challenges around those. There's and just to say, there is clearly a discretion on government to waive or defer those requirements in these instances of Afghanistan. Thank you so much, Adam, and I will stop there.
Brilliant. Thanks very much, Catherine. I understand that's the visa form which many Afghans may want to use if they're applying for leave outside the rules. The one that's considered to be most closely matching circumstances is the family reunion, where the family member in the UK has refugee status. Now, for most Afghans, that won't match their circumstances at all, let alone closely match them, but that's apparently the one that you need to use if you want to apply for leave outside the rules. Erin.
Thanks, Adam. I'll just share my screen so you can see my slides. Hopefully you can see that. Yeah, thumbs up from Adam, great. Thanks everyone for joining. So I'm going to talk about something that arises after you've overcome all of the hurdles that Donnchadh and Catherine have already spoken about. And obviously from experiences of cases that I've been involved in, and I know there are others who are listening who also have cases of a similar kind, and their experiences may have been different. But for my cases, this is something that's arisen in cases of patrol interpreters. So let me just get the next slide. The patrol interpreters that I've been working with usually were granted eligibility under the ex gratia scheme. So this was the scheme that came long before ARAP, and it's been in place. It was in place from 2013 and was open until November 2022. And in between that time, ARAP came along and superseded it. But it was a benefit of employment for patrol interpreters who worked for the British military in Afghanistan, and it was based on a recognition of service. So that's the eligibility criteria for the relocation offer under the EGS. And so then also, obviously, people who come under ARAP may also encounter the problems we're going to speak about, because either way, no matter which way you are granted eligibility for relocation, the next stage is that the Ministry of Defence will pass your application over to the Home Office to determine your application for entry clearance. So it's a two-stage process. First, you're granted eligibility for your relocation to the UK, and then your application is passed over to the Home Office, and the Home Office decides whether or not you should be allowed to enter the UK. So the main thing that the Home Office is looking at is suitability, as they call it. And this is something that comes within Part 9 of the immigration rules. And there are certain grounds on which a person can be found unsuitable and why they might be refused entry clearance to the UK. So these are some of the grounds for refusal that are listed in the immigration rules. So you've got non-conducive, criminality, false representations, previous breaches of immigration laws, the failure to provide required information, a debt to the NHS, so you've been here before and got, for example, I don't know, emergency medical treatment, or unpaid litigation costs, which is quite a scary one if you don't have cost protection and you're litigating. So non-conducive is highlighted there because that's the ground that we've been dealing with in all the cases that I've been involved in. And here is some more information about non-conducive under the immigration rules. So it refers here to an applicant's presence in the UK not being conducive to the public good because of their conduct, character, associations, or other reasons, including convictions. But obviously, it's not just about have you committed a criminal offence or anything like that. It is just conduct, character, associations, whatever that means. So those, just to go back, those three words there are highlighted because in all of the cases that I've dealt with, that is the extent of the reasoning the applicant is provided for why they have been refused. So it's very broad, and trying to figure out what the reason might be is quite difficult, and we'll come on to that. So there is a Home Office policy about suitability, and it's quite a long document, but just to pull out a couple of points from that. It goes into when a person's presence in the UK might not be conducive to the public good, and some of the factors that might weigh into that decision, but this is in no way exhaustive. So it could be, you know, the nature and seriousness and the frequency of whatever the behaviour is that's been alleged, and what kind of difficulty the UK could experience from admitting a person with that behaviour. Again, quite broad. And then it goes on to give some examples, non-exhaustive, of situations when a person's presence may be non-conducive. So terrorism, member of prescribed organisations, serious violence, serious criminality, association with individuals involved in all these things. So quite broad. So this is just a bit of an extract from one of the refusal letters in one of my clients' cases, but it is identical to quite a lot of them. And as you can see there, as I mentioned earlier, it just says that your presence in the UK has been assessed as non-conducive to the public good on grounds of national security due to your conduct, character, and associations. So that is obviously a very confusing letter to receive if you are on the receiving end of one. And your partner and child will normally receive their own letter, which says they've also been refused because there are serious reasons for considering that their partner or their parent constitutes a danger to the community or to the security of the United Kingdom. Those refusal letters also, up until recently, came with just a line that said, you have no right of appeal or right to administrative review of this decision. Which I know from speaking with a lot of Afghans who've been on the receiving end of these decisions caused a lot of confusion and stress. For some of them, they just gave up. They thought, okay, well, you don't want me, fine. That's it. That's the end of it. There's nothing I can do. Some, you know, not knowing anything about the law in the UK and what their rights were, weren't connected with lawyers until it was too late, or they were getting confusing or conflicting advice from, you know, well-meaning people who were trying to help but weren't legally trained. So it, you know, it did cause a lot of confusion and undue stress. But obviously, even if there is no right to appeal or review, you do have the right to apply for a judicial review if there are grounds to do so. So obviously that is what we did. But now there are, on some of the decision letters we've been receiving recently, they've been certified into SIAC. So there is now the right to apply for a review by the Commission. So watch this space. We'll be doing that in some cases, and we'll see how we get on. So challenging these refusals, this is where it gets interesting, because you don't know what the allegation is that's been made against you, but you have to try and provide your evidence to show why you're not a threat to the UK. And so this is just kind of a summary of some of the issues that we look at when we try to help the clients figure out what needs to go into their witness statement in order to try and give this evidence. So we go through whether there are any possible links to the Taliban and or their supporters. And this can get quite tricky. You know, Afghans have large extended families. They can be spread throughout the country. You know, they may come from the individual may come from somewhere like Wardak province, for example, that, you know, was a Taliban stronghold for a long time. And people who live in those areas will generally not be outspoken against the Taliban because they have to be at least seen to be supportive or not opposing in order to survive. So if your family is from that area, does that mean that they are seen as part of or associated with the Taliban? And by extension, is your association to them a reason to say that you are a national security threat to the UK? On the reading of all of the policy, maybe. You know, possible links and associations could be your school friends, your colleagues, your acquaintances. You may not know them well. You don't know what they do in their spare time. You don't know everything about their background. But just your association with them could mean that you're considered to be a threat to the UK. So, I mean, in one of our cases, I think that there was an issue with somebody's former colleague who, unbeknown to the client until we started to do some digging, was quite problematic. But all of the issues with that, so the former colleague, arose long after our client had stopped being associated with them. So who knows if just the fact that they were known to have known this person was the issue that caused our client to be considered a national security threat to the UK. So then there's also social media, and going through the client's social media profiles to see if there's anything that they might be doing online, even innocently, that could potentially be seen by the Home Office to be problematic, and then giving their evidence about that. Engagement with groups on Facebook that seem innocent, but maybe there's, for some reason, they are flagged as problematic. And obviously Facebook friends. Some of my clients had thousands of people on their Facebook account who they said, oh, I don't really know them, but they're just my Facebook friends. In one case, we extracted all of the names and analysed them as against the UK sanctions list. And quite a lot of name matches came up with the UK sanctions list. But on further investigation with the client about who that person actually was, you could discount them as the person who was named on the sanctions list. So my question would be, does the Home Office carry out that same forensic exercise, or do they say, oh, that person that's a name on the UK sanctions list and you're associated to them? Finally, and probably one of the bigger problems, is to do with issues that have arisen during employment with the British or US military, and having read dozens and dozens of patrol interpreter personnel files over the years, there are certainly themes that run through them. The first being poor record keeping, and obviously in a lot of these cases, these are events that happened a long time ago. But these were also, in the case of the interpreters, civilians without any military training, sent out into the front lines in places like Sangin, which were the most dangerous places in the world at that time. And they were being shot at every day on patrol, encountering IEDs frequently, seeing their friends and colleagues being blown up. It's very stressful situations. They were also navigating cultural differences with the British military. They're out in the desert for months on end, and inevitably tensions were high and disputes broke out, misunderstandings, disagreements. And so in a lot of the files, there were minor disagreements that escalated, that ended up with somebody being dismissed. Could that be evidence of your conduct or your character that could lead the Home Office to say that you're not suitable for entry into the UK? Equally, a lot of interpreters also worked with the US military, same issues there. As we understand it, the US were quite strict with people who were fighting, and they quite often got put onto watch lists. So if you are on a US military watch list, is that evidence against you without any other explanation of why you might have been put on it because of what happened? That could be evidence, arguably, that could be used against you. And we do know that the Home Office makes inquiries before making these decisions. I would assume that some of those inquiries are to other military partners who were in Afghanistan at the same time. We don't know. So the turning point in a lot of these cases was thanks to a decision in ALO, and thanks to the team at DPG, who I think are listening. And this was a JR that was brought on very similar grounds to the ones that we ran. And The decision in ALO was quashed by the High Court because the Home Secretary was found to have failed to carry out the Tameside duty to make reasonable inquiries into these allegations. So the basis for the court's decision was primarily within a closed judgment. But what seems to be the case from all these cases is that the Home Office just did not investigate properly or at all, who we don't know, whatever the allegations had been made, leading to the findings that they were threats to national security. And there's just a couple of quotes about the Tameside principle from Mr. Justice Swift. So thankfully, in most of these cases, we have ultimately received positive decisions, and families are now in the UK or on their way. But that is not without an inordinate amount of undue stress and anxiety. And so this is just a quick case study on unconscionable delays, to quote a High Court judge. And this case in particular really highlights how convoluted this whole process has been, because it wasn't just people being refused. Also, there were refusals which were then withdrawn after litigation was issued that were then to be remade, and there were delays, and it was just a whole ordeal for everyone involved. So in this case, my client was offered relocation under the ex gratia scheme in November 2020. And so the evacuation, just to be clear, happened in 2021. So this was long before the Taliban took control of the country. And so there was plenty of time to get him and his family out. It wasn't until the 30th of July, so that's 7 months later, that the Home Office decided that he was a threat to the national security of the UK. And they didn't notify him until the 10th of August. Now that's significant because the 16th of August was the date that the Taliban marched into Kabul. So there wasn't much that he could do to get out on an evacuation flight in time. Judicial review proceedings commenced on the 29th of October. And then less than a month later, the Home Secretary withdrew the decisions that we were challenging and agreed to give new decisions by the 17th of December 2021. So that date rolled around, and the Home Secretary needs an extension of time, saying they needed to make further inquiries, which seemed positive. We didn't get new decisions until the 18th of February, but they were again refusals. So we were back to square one. We had to issue fresh judicial review proceedings. Obviously, at every stage we were applying and being granted expedition because the client is sitting in Afghanistan like a sitting duck. And at this point, we're now February 2022, we're over a year since he's been told that you can come to the UK by the EGS. So new proceedings issued in the March, and then in July, one day before our skeleton argument was due for the rolled up hearing, the decisions again were withdrawn. And we were told that new decisions would be coming. We were told a few days later that further inquiries were already underway. So that's July 2022. ALO was handed down in September. And so we were in negotiations about how long after that judgment it would be reasonable for new decisions to come. But ultimately, they did not arrive until January 2023. Sorry, they were not due to arrive until January 2023. They didn't arrive in January 2023. They instead arrived on the 15th of February, and that was only after 2 applications of an extension of time, the first of which a High Court judge, as I've said that the delays in this case had been unconscionable. And in response to the second application, the High Court judge ordered that any further extension of time was to be heard in court in person with the relevant Home Office representative giving live evidence to which we would be allowed to cross-examine. So the decisions came very swiftly after that. So ultimately, in February this year, and that was 27 months after an eligibility decision was made under the EGS, the client and the family were approved for entry clearance. And so we're looking forward to welcoming them here as soon as possible. But obviously, that is not the end of the process. Just because you're cleared for entry there's a lot you have to do in order to even get here. So the first thing is get out of Afghanistan. Not easy. Get yourself to a third country. And then if you can manage to do that, present to the British consulate, the British embassy there, and they will give temporary hotel accommodation for people who've been granted entry clearance while they go through the process of doing the biometrics and issuing the actual visas in the passports. Then you have to wait for your flight to be booked to the UK. It could take a long time. And then there's the possibility you'll be put in temporary hotel accommodation in the UK while you wait for there to be housing allocated, or indeed that you find your own housing and work. So it is a very, very long process. And this whole process, even once you've been accepted for entrance, could be the subject of an entire talk itself. That's it for today. So if there's any questions, just put them in the box. Thanks very much.
Brilliant. Thanks very much, Erin. That is extremely interesting, and the depressing 27 months wait in that case, I'm sure won't be unfamiliar to a number of people who work in this area. I'm at this stage in your lunch breaks, I imagine you'll either be settling down for a snooze after a hearty pie, or maybe becoming a bit wired after a double espresso, but I hope to be able to cater to both audiences with my final talk of this session. The first topic I'm going to talk about is national security. My seminar notes are towards the end of your pack. I'm just going to go through the topics as they appear in those notes. So the first of them is national security. As Erin mentioned, there have been a number of cases in which people have originally been offered relocation under ARAP or the ex gratia scheme. But then once the case is handed over to the Home Office, they have leave refused on this non-conducive to the public good ground, where you're given that bare fact that the Secretary of State didn't consider your presence in the UK was conducive to the public good, but you're not given any more information about that. And normally there's some indication in the letter that they're not going to tell you about it because of national security. So that's your decision letter, and then it's for you to think, okay, how do I challenge that? And they are quite challenging cases. Starting with the procedure, on the 28th of June 2022, as Erin has mentioned, a new power was introduced into the Special Immigration Appeals Commission Act in section 2F, which was the power of the Home Secretary to personally certify that a decision like this was taken in reliance on information which, in her opinion, shouldn't be made public because of a risk to national security. Now, that's a personal power, and it's only if the Home Secretary does it herself that the cases are diverted under that power to SIAC. If it's just an official and it hasn't been properly delegated, then the case isn't diverted into SIAC under that power, and instead your route of challenge of the decision is judicial review in the administrative court. Sticking first with SIAC and looking at what procedure you have to follow if a section 2F certification has been made. The procedure is set out in the SIAC rules 2003 and also in some practice notes that SIAC has produced, and I've put a link in my notes to those practice notes. It's a relatively complex procedure. Special advocates are appointed, and then you have to go down into the dark and dingy basement in Field House in order to have all your hearings. Looking then at the administrative court, what happens there, it's a slightly more vague process. What normally has to happen is that the Secretary of State has to make an application once a judicial review claim has been made for a closed material procedure under Part 2 of the Justice and Security Act 2013. The process for that is set out both in that Act and then also in the CPR Part 82. And it can be pretty complicated, bringing together the procedure for a judicial review together with the closed material procedure. It is capable of causing a lot of delay, and that's really the main problem for clients in this area, because normally their cases are urgent. But if the Secretary of State wants to, and they normally do, they can try and use that procedure to cause huge delay in the cases being processed. I've included at the end of the pack some directions from one of the cases I did with Erin called AZ, which are very lengthy, but they give you an idea of the type of directions you might be looking for in order to condense the process and try and avoid too much delay. Those directions have been approved in a number of other cases by High Court judges, and so hopefully they should be of some assistance. I think the main thing for claimants at the first stage is just think about the complexity and try and agree or obtain directions for expedition as early as you can. So what about the substance? How do you go about challenging the substance of your decisions? The first step, which is normally important to do, is to try and get more information of the allegations against your client. It's pretty dangerous tactically to speculate as to what those allegations might be and say, well, these are my responses to a load of hypothetical allegations. Because if you do that, what will normally happen is in close, the Secretary of State will say, well, look, this is inconsistent with X, Y, Z and whatever we've got. And that undermines your credibility and shows that your presence isn't conducive to the public good. So it's normally best to try and get more information. That can be pretty difficult. You can try and rely on the common law, but the common law is excluded if a statute explicitly excludes it. So if a declaration has been made for closed material procedure and material is withheld under that declaration, then the common law requirement of disclosure is excluded by the statute. What you can argue is that, and there's a lot of law to this effect, that the common law requirements for fair procedure have to be respected unless they're specifically excluded by the statute. And you can try and use that argument in creative ways. And what we found works in a number of these cases is first of all, you ask for disclosure of the allegations against you so that you can make effective representations about them. And you might get a bit more. But then you come to the point where a Section 8 declaration for closed material procedure is made. And at that stage, you can say, okay, we're not going to get any more. We've gone as far as we can. So we're going to produce a witness statement, which does the speculative exercise that I mentioned earlier. So you guess what the allegations are, and you say, these are my responses to it. And really, by that stage, that's the best you can do. Although in judicial reviews, normally the court is limited to what was before the decision maker, you can argue, well, to respect a degree of procedural fairness, then the Secretary of State has to reconsider the decision in light of your reasons. That's the only opportunity you have had to make representations about it. And so to respect the sort of duty procedural fairness points, that has to happen. Alternatively, the court has to take into account that information in considering for itself whether the decision is lawful. So you can sort of have two bites of the cherry in that sense. In some context, Article 6 of the European Convention on Human Rights, I'm sure you're all familiar with the AF number 3 requirement for disclosure, which is that in certain contexts, control orders, where liberty is at stake, that sort of thing, there will be a requirement for a minimum level of disclosure, which is sufficient to enable your client to meet the case against them. And that's called AF number 3 disclosure. Now, there have been some efforts to establish that this applies to this type of case. In other words, an ARAP or EGS relocation offer, but then a refusal of leave. And the argument is, well, these are essentially sufficiently important to mean that the minimum level, the core minimum level of disclosure guaranteed by Article 6 is necessary. Now, that argument was rejected in the High Court in ALO, but it was a very limited analysis of the issue. It's a very complicated issue, and I think, at least, that it's worth pushing in the right case to try and raise it again and re-argue it, because I think there's a difficult but credible argument. The case law in Article 6 is really complicated. I don't have time to look into it now, thankfully. But I would like to just refer to a couple of recent authorities that might be of interest to people in this area. The first of them is a case of QX, which was a challenge to a temporary exclusion order. And interestingly, the individual and his family at the time that the temporary exclusion order was granted were outside the territory of the UK. So they were outside our territorial jurisdiction. And despite that, the court decided that the subject was able to rely on Article 8 and also Article 6. And the basis for being able to rely on Article 6 was that the claim was potentially decisive of Article 8 rights. So if you have a type of claim where an individual has family members in the UK and the court proceedings are potentially decisive of whether they have contact with them, then you can say, well, it means then that Article 6 applies, and therefore this requirement for disclosure applies. So it's a very complicated roundabout route. That doesn't work, though, in every context. So R3, a Court of Appeal case, was a deprivation of citizenship case. And there the court said, well, you were outside the UK at the time the deprivation decision was made, you can't rely on Article 8. And so that appears, at least on the face of it, to set up a bit of a conflict between the two cases. There are actually some sorts of subtleties which meant that, well, that at least the courts gave reasons as to distinguishing between the two of them. But anyway, there's a bit of a tension there, and certainly there's going to be quite a lot more litigation about that sort of topic. Moving on to the meaning of conducive to the public good. Erin's already covered this, but there were just a couple of other aspects of it that I thought it would be worth drawing attention to. Conducive to the public good is potentially a very broad term. It sort of means, well, the Home Secretary doesn't really like you. And given the potential breadth of the term and also the great weight that courts give to the Home Secretary's decision in this area, it can make challenges to conducive decisions very difficult. So you have to be a bit clever about it. But there is some guidance in case law, at least, that can help. So Erin's already referred to some of it. The guidance itself, so the Home Office guidance, states that non-conducive to the public good means that it's undesirable to admit the person to the UK based on their character, conduct or associations because they pose a threat to UK society. And it's the threat to UK society terms that might help. You're not talking about here someone who poses a threat to an individual or even to an individual body. It's UK society, it's a broader term, and that's consistent with the words of the minister who introduced this power originally to the Security Services Bill back in 1989. So when it was going through Parliament, the minister, I'm sure the name will give great pangs of nostalgia to many. The Right Honourable Douglas Hurd MP explained that by its very nature, the phrase conducive to the public good refers to matters relating to the survival and well-being of the nation as a whole, and not to party, political, sectional or lesser interests. So it should be a pretty sort of major threat to the country as a whole. Whether it is in practice is another matter. The other element of the definition that might be helpful is that you're not just looking at risk to national security. Conducive has a broader meaning. The Home Secretary is required to take into account not only the threat posed by the individual, but also factors in their favour. So any adverse consequences that refusing them leave may have for them or for their family. And decisions should be proportionate, balancing both the threat and also any factors in their favour. And that can be useful for challenges because in a lot of these challenges, the Secretary of State focuses just on national security points and ignores the favourable points. And so if you might be able to argue, failure to have regard to relevant consideration, failure to make proper inquiries into the adverse consequences or the favourable points for the individual, that can sometimes be a way into these challenges. So that's national security. I'm going to go on and have a quick look at discrimination issues. There have been a couple of interesting cases recently about discrimination between the Afghan schemes and the Ukrainian schemes. So, for example, the case of AB, the argument what in AB, so AB was applying for leave outside the rules and noticed that there was a difference between the Afghan leave outside the rule process and the Ukrainian family scheme process. So in the former case, the Afghan Lotta case, the individual would have to give biometric samples before entry to the UK, whereas in the Ukrainian case, they could wait until they entered the UK to give biometric samples. And that caused them a particular difficulty in their circumstances, and they argued, well, this is discrimination because it's less favourable to them, and that's unlawful. And the court rejected the challenge, but the terms under which it rejected it are quite interesting, and they indicate that this sort of argument might be useful in other cases. So it went through the standard 4 questions that arise in Article 14 discrimination cases, and held, firstly, the case fell within the ambit of Article 8 ECHR because the individual had relatives in the UK. So this is the Afghan individual seeking leave outside the rules. That's very straightforward. The second question is more interesting. You have to, under the second question, identify a protected status. And the court said there is a protected status. It's principally nationality. So that's the protected group that they came from. But the interesting thing about it is the court didn't have to come to the decision that this is that the ground was solely nationality. They said it was principally nationality. Now that's quite different from past cases where if you in the past you have to have exact correspondence normally between the disadvantage that you're complaining of and the group that you're in. And so if it's only some of your group, so for example you're of a nationality only some of whom are disadvantaged, then you've been unable to argue discrimination in the past. But this case said that, okay, even though not everyone in the group is disadvantaged, for example, the Ukrainian scheme only applies to Ukrainians who are resident in the Ukraine on a certain date. So it's not applicable to all Ukrainians. But we don't need to worry about that because there's some protected status here. And so it's sufficient that the mistreatment was principally on the grounds of nationality. So that's a second aspect that was of interest. The third aspect of the case that was interesting as well was that the court was willing to decide that the Ukrainian group and the Afghan group were in analogous situations. And that's even though there are a number of differences between the processes in place. So the Afghan LOTA policy is very different in terms of its criteria and its procedure to the Ukrainian family scheme. But despite that, the court said, well, they're analogous in the sense that both groups are fleeing persecution, and that's sufficient. The court decided the case against the applicants on the basis of justification, that they said essentially the Secretary of State had put forward rational grounds for justifying the difference in treatment. For example, it's more difficult to provide prior the process is more difficult for Afghans. There's greater risk of national security from Afghanistan, and the court said that was sufficient. And that's perhaps understandable. But I think the main point to take from those cases is that there are a number of other aspects in which the schemes from the two different locations are different. And you may use that case to try and challenge those if there's no obvious justification for those differences. Another area of discrimination concerns the Sure Start maternity grant. So the Sure Start maternity grant is you get £500 for your first baby to help you with the costs. There's a first child only rule, which is that you only get that for your first baby. So if you have a second child, you don't get the grant. Some asylum seekers in a case called SK and LL challenged that and said that it was discriminatory against them, essentially on the basis that if you're fleeing persecution, you're probably not going to bring with you your cots, your tools, your baby clothes, and so on. And so you were in a different situation from ordinary people who've had a first child. And so they used the argument of flinemos discrimination. I'm sure we'll come across it. It's a slightly different type of discrimination where there's a rule that applies to everyone, and the discrimination is treating everyone the same. So you can successfully argue flimenos discrimination if you show that your group is significantly different and therefore should have been treated differently. And they succeeded in that in SK because they showed refugees fleeing persecution aren't going to have their baby items with them, and so they should be treated differently. And as a result of that, it's filtered into the Afghan and Ukraine context, and that a new policy has been produced following a successful challenge, which said that the first child only rule doesn't apply in that context. I know I've only got a couple more minutes, so I'll just quickly look at housing and benefits issues for those relocated under the Afghan resettlement schemes. Now, there were some lofty promises made at the start as we've heard, the debt of gratitude. The government's going to provide all the support that's necessary for Afghans to resettle successfully into the UK. The reality is that 18 months after resettling, thousands of Afghans remain in hotel rooms with 5 children, living in squalid conditions. A decision was made recently to close all hotels in London, meaning that many families had to be moved right to the other end of the country. Education was disrupted, health was disrupted. It's a pretty terrible situation, which is completely contrary to those promises. There are some policies which govern the housing and benefits scheme, which I've mentioned in my seminar notes. And a summary of the schemes is also set out in the seminar notes. It basically allocates roles between local authorities and the Home Office as to the provision of bridging accommodation, how permanent accommodation is found, and how decisions about that are made. There has been a challenge by a group of claimants in which I'm involved to decisions to close bridging accommodation in London and to move the group to the other end of the country. And the challenge argues that partly there were failures to have regard to relevant considerations, for example, the children's welfare, their education, employment being interrupted, and also failures to carry out the Tameside duty, so to investigate into those areas as to exactly what would happen. Anyway, judgment is awaited in those cases, and we anticipate that it will be out very soon. So that was a bit of a whistle-stop tour through everything. I hope that has been helpful. Thanks very much to all the speakers and to Doughty Street for arranging this. And thank you all very much for attending. I know there's not been any questions today, which is fine, but if you have any questions in future and would like to email at least me, I would be very happy to try to answer them. Thanks again for attending.